Welcome back to the Jamga Mind Canada series. I'm your host, Etienne Newman. Today we are bringing the fight home to Alberta. We are decoding the Health Information Act, or HIA. If you are a founder or a hospital leader in Calgary, you know the struggle. You want to use modern cloud tools, but the HIA was written before the iPhone existed. The big question is, can you legally process Alberta patient data on a US cloud server? Most people think the answer is a hard no. But the reality is actually a complicated maybe if you know how to navigate Section 60. Our AI intelligence agents have analyzed the OIPC guidelines to debate the risks of the cloud, the nightmare of privacy impact assessments, and the difference between data residency and data sovereignty. Let's enter the simulation.
Welcome back to the deep dive. Today, we're stepping inside a boardroom. Picture this. The air is tense, and a massive contract is on the line.
And at the table, you have this urgent collision. It's a clash between the drive for innovation and the strict, uncompromising letter of the law.
Absolutely. The whole conflict is about the future of healthcare data right here in Alberta. You've got a Hospital CIO, and they are pushing hard to use the big cloud platforms.
Right, the AWS, the Google, the Azure, they want to leverage all that power, all that AI to analyze patient records. The goal is, better, faster clinical outcomes.
But standing in their way is legal counsel, holding up a copy of the Alberta Health Information Act, the HIA, and saying, hold on, this move is incredibly dangerous.
Dangerous to the tune of losing a huge AHS contract. We're talking massive disruption and potentially million-dollar fines. This isn't just a theoretical argument.
Not at all. And for you listening to really get this, we have to understand the roles. The law defines them very clearly, and it all comes down to who carries the risk.
It does. First, you have the hospital. Under the HIA, they are the custodian. That's the key term. It means they are ultimately legally responsible for protecting the data.
And the cloud company. The AI startup they want to hire.
They're the information manager. They handle the tech, the processing, the storage, but, and this is the critical point, the law makes it clear the custodian can't just pass the buck.
So the liability always stays with the hospital.
It always stays with the hospital. And that tension, the CIO's dream of innovation versus the hospital's absolute legal accountability. That's what we're breaking down today.
So our mission is to dissect the 4 key battlegrounds where this fight is happening. We want to show you exactly why moving Alberta patient data to the global cloud is so fraught with legal peril right now. Let's start at the beginning with the core philosophy of the Act itself.
We have to. If you miss this, nothing else makes sense. The HIA's #1 purpose is, and I'm paraphrasing here, to create strong, effective ways to protect people's privacy.
Okay, strong protection. Makes sense.
But it's more than that. It specifically says that data should be used in the most limited way and with the highest degree of anonymity possible. The default setting is extreme caution.
But wait, that's where the CIO would just slam their fist on the table. The HIA can't just be a digital Fort Knox. If it were, you couldn't run a hospital.
Well, you're right. There's another purpose baked in.
Exactly. The flip side is enabling information to be shared and accessed to actually provide healthcare and, manage the health system. The CIO's whole argument is that AI is crucial for that management piece, for planning, for resource allocation, for quality improvement. You can't do that with data locked in a filing cabinet.
And that's the perfect summary of the two opposing forces. But the law puts a huge procedural speed bump in the CIO's path. It's what's called the duty to collect, use, or disclose with anonymity.
A procedural speed bump. Unpack that for us. What does it actually force the CIO to do?
It creates a kind of hierarchy for data. Before a custodian, so the hospital, can even touch individually identifying health information, they have to do their homework. They have to first ask, can we do this with aggregate data? Can we do this with non-identifying data?
So try the anonymous route first. That's step 1.
That is the mandatory first step.
But that sounds, completely impractical for modern AI. These machine learning models, they need enormous amounts of raw, granular, real-world data to find the patterns that lead to breakthroughs. Doesn't this rule basically kill the project before it even starts?
It doesn't kill it, but it slows it down immensely. Because the hospital can't just claim they need identifiable data. They have to effectively prove that the anonymous approach is genuinely not good enough.
They have to prove it.
Yes, and even if they do, they're only allowed to use the absolute minimum amount of information needed for that one specific purpose. The law couldn't care less about convenience or speed. It cares about necessity and limitation. It's a huge hurdle.
I get it. So hurdle 1 is proving necessity. Let's move to the real flashpoint in this whole debate, putting the data on servers outside of Alberta. The CIO needs the scale of a global cloud provider.
And this is where the compliance alarm starts screaming. We are now talking about Section 60 of the Act, the duty to protect health information, and specifically the part that deals with foreign jurisdictions.
What does it say?
It says the custodian has to take reasonable steps with all kinds of safeguards to protect data that is stored or used in a jurisdiction outside of Alberta.
Okay, but the cloud provider will immediately say, no problem, we'll use data residency. We have a data center in Montreal, one in Toronto. The data never leaves Canada. Does that solve it?
And that's the classic mistake. It solves for data residency where the data lives, but it does not solve for data sovereignty who has legal power over that data.
Okay, residency versus sovereignty. Explain that distinction.
Most of these hyperscalers are American companies, right? Headquartered in the U.S., so even if their server is in Montreal, they are subject to U.S. law.
And that brings up laws like the U.S. Cloud Act.
Precisely. The Cloud Act could potentially allow a U.S. authority to compel that U.S. company to hand over data, even if it's stored on Canadian soil. And that triggers a kind of poison pill buried deep in the HIA.
Another section. Which one?
It's Section 107, and it says that no person in Alberta shall knowingly disclose health information because of a subpoena or warrant from a court that has no jurisdiction in Alberta.
Wait, so if a U.S. court orders a U.S. cloud company to access data on its server in Montreal,
the Alberta Hospital, the custodian, is now in a position where they could be violating the HIA because their data has been disclosed under foreign legal pressure.
so those reasonable steps and safeguards from Section 60 become almost impossible to meet. How can you safeguard against a subpoena from another country's government?
You can't. That's the problem. The moment you use a system that's subject to another country's laws, you've compromised your ability to meet that duty under the HIA. It's a massive, maybe even unacceptable risk.
Okay, this is a huge obstacle. Let's shift to the next one, the procedural one. The Privacy Impact Assessment, the PIA. I hear CIOs complain constantly that this process just kills innovation. It takes months, maybe even a year.
I get the frustration with speed, I really do. But the PIA isn't just red tape. It's the hospital's mandatory legal homework. It's their only real legal shield.
So what is it exactly?
It's a document. Before you implement any new system or process that uses identifying health information, you have to create a PIA. You have to map out exactly how it works and, crucially, how you're going to protect privacy.
And then what happens to this document?
You have to submit it to the Information and Privacy Commissioner's office for review and comment. And you have to do this before you go live.
And that's why it takes so long. The commissioner's office is going through it with a fine-toothed comb.
Of course. They're looking for holes, they're stress testing your plan, they're making sure privacy isn't just a feature you bolted on at the end, but that it's baked into the design from the very start.
So if our CIO wants to use a new AI tool on the cloud, what's the commissioner looking for in that PIA?
Oh, they're looking at everything we've just talked about. They'll ask, did you follow the data minimization rules? Did you try to use anonymous data first? Then they'll hammer you on Section 60. How exactly are you protecting this data from foreign legal orders? They'll want to see your contract with the vendor. Is it airtight?
And this applies to everyone, right? Even the biggest health agencies can't just skip this step if they're rolling out a new system.
No one gets a pass. Which brings us perfectly to the last theme, the end game. If it all goes wrong, if the safeguards fail and there's a breach, who pays the price? This is what we call the custodian trap.
Right. The CIO's thinking, I've hired Amazon, I've hired this cutting-edge AI firm, they're the experts, surely they take on the risk.
And that is the single most dangerous assumption a custodian can make. Yes, the vendor is an information manager. Yes, you must have a written contract with them that details all their responsibilities.
And yes, the vendor themselves has to comply with the HIA.
Correct. But then you get to Section 66, subsection 6. It's the one sentence that should keep every hospital board member up at night.
What does it say?
It says, a custodian continues to be responsible for compliance with this act. Full stop. The liability doesn't transfer. You can't contract your way out of your legal duty.
So even if the cloud provider is the one who technically messes up, the fine lands on the hospital's doorstep.
The fine, the legal responsibility, the public fallout, it all lands on the custodian. That's the trap.
And these fines are not trivial.
Not at all. For an organization, the maximum fine for knowingly breaking the rules is up to $1 million. That $1 million hammer hits the hospital. It's why this isn't just a technical decision, it's a profound business risk.
So this deep dive really paints a picture of this incredible professional dilemma for healthcare leaders in Alberta. You have this undeniable pull of AI and innovation clashing with the ironclad framework of the HIA.
We've seen it across the board. The limits on data use, the near impossible challenge of using global cloud services because of foreign jurisdiction risk, and this final accountability trap that means the buck always stops with the hospital.
So what's the key takeaway for someone listening to this?
The key takeaway is that under the HIA, the guiding philosophy is still deep caution. It's still maximum anonymity. And all the promised efficiency of new tech doesn't let you skip the procedural diligence of the PIA or escape the fundamental accountability of being a custodian.
Compliance isn't optional. It's the whole game.
It is the whole game.
That's the landscape today. But here's the thought I want to leave you with. The HIA actually has a built-in review mechanism. The law requires a special committee to review the Act periodically. And part of that review is to look at how the Act applies to entities that aren't custodians but still hold health data.
Like the big tech companies.
Exactly. So the question is, does the current Act, even with its recent updates, truly reflect the reality of global cloud computing and AI? Or is this tension, this conflict we've been talking about, permanently baked into the legislation until that next statutory review fundamentally rethinks how Alberta deals with data sovereignty in the modern age? Something to think about. Join us next time for the deep dive.
Look, I'm just going to say it. The Health Information Act is killing us. We have doctors in Calgary spending 3 hours a day typing notes into an EMR that looks like it was built in 1998. Meanwhile, I have a vendor offering a generative AI tool hosted on Google Cloud that could automate all of it. But every time I bring it up, your team screams, "Data sovereignty," and shuts me down.
We don't scream, Mark. We cite the law, specifically the HIA. You want to ship patient data to a server in Oregon. I am telling you that is a liability minefield.
But it's encrypted. The vendor signs an NDA. Why does it matter if the server is in Oregon or Red Deer?
It matters because of Section 60 of the HIA. It deals with disclosure outside Alberta. When you use a U.S. cloud provider, you aren't just storing data. You are technically disclosing it to a jurisdiction subject to the U.S. Cloud Act.
Okay, so what? The U.S. government is going to subpoena Mrs. Smith's knee surgery records? That's a paranoid fantasy.
It's a legal reality. Under the HIA, the custodian, that's us, the hospital, is responsible for that data 100% of the time. If that U.S. vendor has a breach, or if the FBI compels them to hand over a server, we are the ones the OIPC investigates. We are the ones facing the fines.
Fine, so we sign an Information Manager Agreement, an IMA, that makes the vendor an agent of the hospital. Problem solved, right?
An IMA is the bare minimum, Mark. It is not a get-out-of-jail-free card. You can't just sign a contract and ignore the architecture. Does this vendor have a privacy impact assessment, a PIA, accepted by the commissioner?
A PIA takes 6 months to review. If I wait for a PIA approval, the technology will be obsolete by the time we launch.
Then you don't launch. Listen to me. The Alberta OIPC, Office of the Information and Privacy Commissioner, does not play games with unrecognized cloud deployments. If you deploy a system that collects health information without a submitted PIA, you are in direct violation of the Act.
So what's the workaround? Do I have to build a server farm in the basement?
No, you need data residency controls. If the vendor can guarantee the data stays in a Canadian region, like AWS Montreal or Google Toronto, and you have the IMA in place, and you've submitted the PIA, then we can talk.
That sounds expensive.
It's cheaper than a class action lawsuit for failing to protect patient privacy.
Fine. I'll call the vendor, I'll ask for the Canadian data residency guarantee and the encryption keys. But you're writing the PIA.
I'm already writing it. Just don't plug anything in until I say go.
That was the intelligence briefing on the Alberta HIA. The key takeaway? The HIA does not explicitly ban the cloud, but it demands rigorous governance. If you don't have an approved Privacy Impact Assessment, PIA, from the OIPC, you are dead in the water. For startups, this means your architecture needs to be privacy by design from day one. For hospital CIOs, it means the custodian carries the liability, not the vendor. To get these briefings delivered to your inbox, covering everything from Alberta provincial law to Federal Bill C-27, subscribe to the full Canada series at jamgamind.com. Don't read the regulation. Listen to the risk. I'll see you in the next briefing.